Cecilia Locsin versus Puerto Galera Resort. Facts: Quinto is the owner of Puerto Galera Resort in Oriental Mindoro. Sometime in 1993, Padilla, a resort manager and developer, entered into a lease contract with Quinto over the hotel complex and given the right to introduce improvements to the property. Later, Padilla and Quinto executed a Memorandum of Agreement, MOA, to look for prospective tenants of the hotel and to jointly share earnings thereof. Then, Padilla and Quinto agreed to lease the hotel complex to Cecilia, who paid a security deposit of $500,000 and immediately took possession of the hotel complex. After 1 year, Quinto visited the hotel complex, and to his utter shock, he discovered that the premises was totally damaged. The place was a total mess and in a state of ruin. Consequently, Padilla, in his personal capacity and in behalf of Resort and Quinto, instituted a complaint for damages against Cecilia pursuant to the Special Power of Attorney, SPA, executed by Quinto in favor of Padilla. Cecilia countered that there was no perfected contract of lease to begin with. During trial, Quinto revoked the SPA given to Padilla. He said he did not fully understand the contents of the SPA he accomplished in favor of Padilla to pursue the case. On the basis of Quinto's revocation of the SPA, the trial court granted Quinto's motion to dismiss. The trial court explained that the said revocation expressly repudiated Padilla's authority to represent Quinto in this case. Suit. Finally, the trial court clarified that there was no perfected contract of lease between the parties as the lease agreement failed to materialize. Padilla is not a real party in interest who stand to be benefited or injured by the judgment in the suit. Issues: 1. Whether the SPA or the contract of agency between Padilla and Quinto had been effectively revoked by Quinto. 2. Whether there was a perfected contract of lease. 3. Whether Padilla is a real party in interest. Ruling: as to the first issue, the contract of agency was irrevocable. Thus, the SPA did not effectively revoke the contract of agency. A contract of agency is generally revocable because it is a personal contract of representation based on trust and confidence reposed by the principal on his agent. However, an exception to the revocability of a contract of agency is when it is coupled with interest. For example, if a bilateral contract depends upon the agency, or if it is the means of fulfilling an obligation already contracted. The reason for its irrevocability is because the agency becomes part of another obligation or agreement. It is not solely the rights of the principal, but also that of the agent and third persons which are affected. Hence, the law provides that in such cases, the agency cannot be revoked at the sole will of the principal. Quinto, in this case, cannot revoke at his whim and pleasure the SPA which he had executed in favor of Padilla and duly acknowledged before a notary public. The agency, to stress, is one coupled with interest which is irrevocable since Padilla has a material interest in the hotel complex, having spent a substantial amount of money for its renovation and improvement. The mutual interest of Quinto and Padilla being the owner and developer, respectively, of the hotel complex is exactly the reason why they entered into a MOA, wherein they agreed to look for potential lessees of the hotel complex with a view to sharing in the actual income derived therefrom. The SPA, therefore, is the means of fulfilling an obligation already contracted, which is the MOA in this case. So, it cannot be revoked on the whim of Quinto. 2. Padilla is a real party in interest. Under the rules of procedure, interest means material interest, that is, an interest in issue to be affected by the judgment, while a real party in interest is the party who would be benefited or injured by the judgment, or the party entitled to the avails of the suit. In this case, it was established that Padilla introduced improvements in the property. Certainly, with the huge amount of money he spent therefore, Padilla stands to be benefited or injured by the judgment in the instant case, as well as the orders and decisions in the proceedings a quo. 3. Was there a perfected contract of lease? Yes. A contract has 3 distinct stages: preparation, perfection, and consummation. Preparation or negotiation begins when the prospective contracting parties manifest their interest in the contract and ends at the moment of their agreement. Perfection or birth of the contract occurs when they agree upon the essential elements thereof. Consummation, The last stage occurs when the parties fulfill or perform the terms agreed upon in the contract, culminating in the extinguishment thereof. Here, Cecilia manifested her intention to lease the hotel complex through a letter, which was accepted by Quinto and Padilla. The parties agreed that the period of lease shall be for 10 years beginning October 2006, with a monthly rental of $90,000 for both the hotel and store areas. To consummate the agreement, Cecilia admittedly deposited a down payment of $500,000. Thereafter, she took over the hotel complex through her assistant, the stay-in caretaker. Cecilia also paid the rentals for the months of October, November, and December 2006 and January 2007 as evidenced by the disbursement and check vouchers presented by Padilla. Under the circumstances, it is clear that there was a perfected contract of lease between the parties.